政府議
Government motions. The Chief Secretary for Administration will move 3 proposed resolutions. First motion, proposed resolution under Section 7(a) of the Legal Aid Ordinance. Second motion, proposed resolution under Section 22A of the Legal Aid Ordinance. And third motion, proposed resolution under the Criminal Procedure Ordinance. Members have been informed that as the 3 motions all relate to the financial eligibility limits or fees under the legal aid schemes, this Council will proceed to a joint debate on the motions, and then the motions will be voted upon one by one. The joint debate now begins. Members who wish to speak, please press the Request to Speak button. I now call upon the Chief Secretary to speak on the 3 motions and move the first motion. Chief Secretary. President, I move that my first motion, as printed on the agenda, be passed to adjust the financial eligibility limits for legal aid applicants. Later, I will move that the other 2 legal aid-related motions as printed on the agenda be passed, seeking to adjust the Director of Legal Aid first charge and make the Legal Aid in Criminal Cases Amendment Rules 2024 to adjust the criminal legal aid fees respectively. First, I introduce the first resolution. Legal aid services form an integral part of the legal system in Hong Kong. The policy objective of legal aid is to ensure that all those who comply with the regulations of the Legal Aid Ordinance, LAO, and have reasonable grounds for pursuing or defending a legal action in the courts of Hong Kong will not be denied access to justice due to a lack of means. All legal aid applicants must satisfy both the means test and merits test as provided for in the LAO. Currently, there are 2 legal aid schemes under the Legal Aid Department, namely the Ordinary Legal Aid Scheme and the Supplementary Legal Aid Scheme. Different financial eligibility limits are set for the 2 schemes in accordance with Sections 5 and 5A of the LAO respectively. Pursuant to Section 7(a) of the LAO, the LegCo may, by resolution, amend the relevant financial eligibility limits, or FELs. Pursuant to the mechanism established in 1999, FELs are subject to review annually by making reference to the Consumer Price Index C. According to the latest round of review, for the reference period from July 2023 to July 2024, the CPIC has increased by 2%. Hence, we propose to adjust the FELs upwards by 2%, namely A, from $440,800 to $449,620 for OLAS, the Ordinary Legal Aid Scheme, and B from $2,204,030 to $2,248,110 for SLAS, the Supplementary Legal Aid Scheme. President, I now introduce the second resolution. If a legally aided person is successful in recovering or preserving any money or property in the proceedings concerned, the Director of Legal Aid has the right to retain thereunder such sums required for recovering the costs and other expenses incurred by LAD for the legally aided person under Section 18A(1) of the LAO. Such right is called the DLA's first charge. However, according to Section 18A(5) of the LAO, the Director of Legal Aid's first charge does not apply to the first $9,540 of each monthly payment of maintenance payment. Separately, when the Director of Legal Aid is satisfied that the exercise of the DLA's first charge would cause serious hardship to the legal aided person, DLA may, in accordance with the principles of fairness and justice, exercise discretion to reduce the amount to be retained, provided that the sum to be reduced does not exceed the cap as specified in Section 19B(1)(a) of the LAO. Pursuant to Section 22A of the LAO, LegCo may, by resolution, amend the rate of maintenance payments that's exempted from the DLA's first charge, as well as the cap on the amount by which may be reduced in cases of serious hardship. In response to the increase in CPIC by 2% for the reference period from July 2023 to July 2024, as mentioned above, we propose to accordingly adjust the two above-mentioned specific amounts upwards by 2%, namely A, the amount specified in Section 18A Bracket 5 upwards from $9,540 to $9,730, and B, the cap on the amount specified in Section 19B Bracket 1 Bracket A upwards from $114,140 to $116,420. President, my third resolution seeks to make the Legal Aid in Criminal Cases Amendment Rules 2024 to adjust the criminal legal aid fees. At present, LAD pays fees to counsel and solicitors in private practice engaged to undertake litigation work for criminal cases on its behalf. The fees are stipulated in the Legal Aid in Criminal Cases Rules. Pursuant to Section 9A Bracket 1 of the Criminal Procedure Ordinance, any amendment to the rules for adjusting the criminal legal aid fees are subject to the approval of the LegCo. On the other hand, to ensure that neither LAD nor the Department of Justice would have unfair advantage in competing for the same pool of lawyers, DOJ draws reference to the same scale of fees to engage counsel and solicitors in private practice to appear for the prosecution in criminal cases. Duty lawyer fees will be paid to lawyers who provide legal representation to defendants in magistrates' courts and juvenile courts through the duty lawyer service. Pursuant to the mechanism established in 1992, the fees mentioned above, that is, the criminal legal aid fees, prosecution fees, and duty lawyer fees, are subject to review on a biennial basis to take into account changes in CPIC during the reference period. According to the latest biennial review, the CPIC for the reference period, that is July 2022 to July 2024, increased by 3.9%. As such, we propose to adjust the fees upwards by 3.9% accordingly. We have informed the LegCo panel on administration of justice and legal services of the outcome of the reviews regarding the proposed adjustments in the three resolutions mentioned above via an information paper in October this year. Members raised no objection to the proposed increase. Subject to LegCo's approval of the resolution, we will implement the proposal upon gazettal of the resolution. Separately, when LAD implements the increased criminal legal aid fees, the government will accordingly adjust the scale of prosecution fees and duty lawyer fees administratively. I appeal for members' support for the above three resolutions. Thank you, President. I now propose the question to you that the Chief Secretary's first motion be passed. Mr. Lam Chun-sing.
Thank you, President. I support the change to the financial eligibility limit of the ordinary and supplementary legal aid schemes by 2%. The point about the legal aid schemes is that we don't deny people justice because of their lack of means. People went to different levels of courts for various kinds of suits and also judicial review. Some may think certain cases of JR are politically motivated. Those are simply people trying to bring down the government. But workers also try to get justice by applying for judicial review. In 2016, there was a CFA ruling on how the ex gratia payment is calculated under the Protection of Wages Upon Insolvency Fund. The court found it for the workers because it started with the workers' perception that there was something wrong about the way the payment was calculated. The court believed workers wouldn't have bothered to take the case all the way to the CFA simply over a few tens of thousands of dollars. Something bigger was at stake. After that ruling, some workers became entitled to a few more $1,000s, and that met their pressing needs. There were applications to the PWIF. where the companies went into the winding up process. There were cases where workers were owed their wages. These workers did not qualify for legal aid. They had to pay tens of thousands of dollars out of pocket for lawyers' fees. It was a major struggle for those workers to decide whether they should spend money on the case. Now the Labor Department joins the winding up procedure so that the workers don't have to initiate this process and workers no longer have to worry about the money. So the Labor Department did the right thing. Most labor disputes can be settled at the Labor Tribunal. At that tribunal, no legal representation is allowed. So workers don't have to apply for legal aid for those cases. And when the Labor Tribunal rules in favor of the workers, but the other party appeals the case to an upper court, that changes the story. The employers hire lawyers. Trade unions dealt with cases in the past. The workers wanted to hire lawyers. They managed to get legal aid, but because of insurance which counted towards the legal aid means test, and even then the workers had to pay $70,000 to $80,000. They had to pay that into the legal aid to recover $100,000. The Labor Tribunal found for the workers for the reasons. So the workers had a case. So maybe we can have discretion where in certain cases workers can pay less into the legal aid scheme. That way, when you have an appeal from a legal tribunal ruling, workers don't have to worry about the expenses. 10 years ago, 5% of civil cases saw applications for legal aid rejected. That rate went up to 7% last year. Some people were denied legal aid after the means test. We don't see a surge yet, but we ask the government to keep close tabs on this rate. Are we seeing more applications rejected because of failing the means test? If that's the case, why? And then we should look at whether there's a need to fine-tune the system. I so submit. I support the resolutions.
Does any other member wish to speak? Ms. Eunice Yong.
Ms. Eunice Yong. President, I want to declare an interest. I'm a barrister. I used to work on a case involving the legal aid scheme. Does any other member wish to speak?
If not, we now...
President, I just want to make the same declaration. Ms. Maggie Chan. President, I'm a brief-out lawyer with the Legal Aid Department. Dr. Junius Ho. President, please don't just hold your microphone. I want to declare that I have no declaration to make. Professor Priscilla Leung, I'm a practicing barrister. We shouldn't have to declare our interests, but since everyone is declaring, Mr. Jimmy Im, I want to declare that people at my firm work on these cases. Mr. Holden Chow, my law firm also takes cases from the Legal Aid Department. Does any other member wish to speak? If not, I now invite the Chief Secretary to give a reply, and then the debate will come to a close.
President, I thank members' support for the 3 resolutions and their suggestions. As mentioned, legal aid services form an integral part of the legal system in Hong Kong. The policy objective of legal aid is to ensure that all those who comply with the regulations have reasonable grounds for pursuing or defending a legal action will not be denied access to justice due to a lack of means. Under the DLA's first charge, there are the 2 types of fees. Mr. Lam's examples show that legal aid services play an important role in the legal system in Hong Kong. I'm going to give a brief reply to what members said just now. In providing legal aid services, we have to seek to protect legal aided persons' interest while maintaining prudent use of public funds, so as to ensure that the public is provided with reasonable channels to seek legal aid, and then the precious legal aid resources are properly utilized to benefit people with genuine needs. The Legal Aid Ordinance clearly stipulates that an applicant must pass both the merits test and the means test before being granted legal aid. Apart from waiving the means test for legal aid applicants in human rights cases under Section 5AA of the LAO, the Director of Legal Aid does not have the discretion to waive the means test for individual civil cases or applicants. President, I so submit. I hope members can support the passage of the 3 resolutions. If the resolutions are passed in the Legislative Council, they will take effect after its gazettal. We now first vote on the Chief Secretary's first motion. I put the question to you that the Chief Secretary's first motion be passed. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Chief Secretary, you may move your second motion.
President, I move that my second motion as printed on the agenda be passed. I propose the question to you that the Chief Secretary's second motion be passed. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Chief Secretary, you may move your third motion. President, I move that my third motion as printed on the agenda be passed. I propose the question to you that the Chief Secretary's third motion be passed. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. I now suspend the meeting until 9 a.m. tomorrow.